It's always a pleasure to speak here at the K Spiritual Center, so I really appreciate the opportunity. But it's also a pleasure to share the panel with Raha and Human Rights First. I've also known the organization from a long time ago, and I've always been very impressed with its accomplishments. I do want to thank you for your very generous words, Joe, as well. I do want to say that I'm going to address this topic from the perspective of my current job as the United Nations Special Rapporteur on Torture. My full-time job is here at the university, at the law school, but my volunteer job for the United Nations is being the Special Rapporteur on Torture, which means that I visit countries and I work on individual cases and I write thematic reports about this mandate that I've been given to promote and try to enforce as much as I can the international legal framework on that applies to torture and cruel, inhuman, and degrading treatment or punishment. It's a huge mandate because cruel, inhuman, and degrading treatment can be also prison conditions, for example. So by default, I suppose, I'm also the special rapporteur on the rights of people deprived of freedom. And because it's what they call a charter-based mandate, not a treaty-based mandate, theoretically at least I have jurisdiction, if you can call it that, over 194 countries that are members of the United Nations. So you can imagine how huge this mandate is. But principally, I want to say that I have to apply the international legal framework that applies to torture, and it's a very detailed one. Compared to other human rights violations, the international community has dedicated quite an interest on torture, and particularly with the hope of one day abolishing torture from happening at all. Like we once did with slavery, for example. We are very far from that, unfortunately, but we do have some important accomplishments, and particularly in terms of standards. And I want to introduce those standards to you very quickly because it has a bearing on the report of the Senate Select Committee on Intelligence and the debates about it that we're facing today. First, the international law absolutely, categorically, and unmistakably prohibits torture under all circumstances. And it prohibits not only torture, but also cruel, inhuman, and degrading treatment, which is a lesser form, a form with less seriousness of torture, and one that also does not require the specific intent that torture requires, and therefore can be perpetrated by negligence rather than by intent. But both torture and cruel, inhuman, and degrading treatment, as I said, are absolutely prohibited. And the prohibition is a norm that in international law we call jus cogens, meaning that it's an imperative norm of international relations that no country can depart from under any circumstance. It doesn't depend on a country signing and ratifying a specific human rights treaty. It doesn't even depend on whether a country is or not a member of the international community. This prohibition applies to them anyway. And it applies without exceptions with regards to emergency situations or any other kind of circumstance that states might invoke to say, well, yeah, well, we agree that torture is prohibited, but we are under a very special circumstance here. No special circumstance is admitted under international law. From that prohibition stem several other international standards that are, in fact, there are state obligations that are very important. One is the obligation to prevent torture. The obligation to prevent torture in the Convention Against Torture, which, by the way, the United States is a party to, has signed and ratified, takes the measures like training your security forces, reviewing their conduct regularly, establishing civilian and other horizontal controls over them. But most importantly, prevention is done by making sure that there is accountability for every act of torture that happens. We'll get back to that in a second, but the obligation to prevent, as I said, applies both to torture and to cruel, inhuman, and degrading treatment. And so the torture memos that Joe alluded to, that were first kind of confidential documents, but then they were withdrawn by the George W. Bush administration once they were leaked to the press. So in fact, they never really acquired any kind of legal status. Make a very crucial mistake. It's not a mistake. I think it was deliberate in trying to parse out what might be cruel, inhuman, and degrading treatment, and what might reach the level of torture, depending on the level of gravity and on the purpose pursued in inflicting pain and suffering of this sort. Now that's all well and good, but there's the purpose of the memo was to instruct people as to when they should expect to be prosecuted or not. And in saying that for cruel, inhuman, and degrading treatment they won't be prosecuted, they neglected to say that the conduct is still prohibited, it's still forbidden. And whether there's, and one could even argue as to whether, in fact, at least under domestic law, they might be right that there's no prosecutorial discretion that obliges prosecutors to prosecute cruel, inhuman, and degrading treatment, where there is an obligation to prosecute torture. But in international law, that distinction is not that way, because under the obligation to prevent torture from happening, it includes the obligation to prevent cruel, inhuman, and degrading treatment, and because a major way of preventing is making sure that there's no impunity for those acts, this obligation to prevent through prosecution and punishment applies to both. There are two or three other important obligations that I'm going to mention very summarily for you. One is what we call the exclusionary rule, the obligation to exclude evidence that was obtained under torture from being used in proceedings against a person who makes the statement. Another one is the non-refoulement provision, meaning that states cannot, under any circumstance, send somebody back to a place where he or she would be at risk of being tortured. There's also obligations to offer reparations and rehabilitation. And here I want to the victims, obviously. I want to pause, because part of the obligation to offer reparations and rehabilitation is the obligation to give the victims an access to justice. And so a state that prevents these cases from being heard in criminal or even in civil cases, let's say, for example, seeking damages, is denying the victim of torture an access to justice and a right to a remedy. And the right to a remedy for torture is an absolute obligation of the state, cannot interfere with it. Unfortunately, even under the Obama administration, the Justice Department takes the position that it will object to cases even against civilian or commercial enterprises under the state secrets doctrine. That is, if the access to justice will have the potential of revealing matters that the executive branch wants to remain secret, then there's no remedy. There's no access to justice. But the most fundamental obligation that is derived from the prohibition on torture is the obligation to investigate, prosecute, and punish every act of torture. And here, the late Professor Antonio Cassese from Italy used to say that the torture is unique in that sense, because even a single event of torture triggers the obligation of the state to investigate, prosecute, and punish it. After he died, the UN Convention on Disappearances does the same. So now we can say that for torture and for disappearances, even a single event triggers the obligation to prosecute and punish, to investigate, prosecute, and punish. It doesn't have to be part and parcel of a widespread or systematic pattern, which would make torture or disappearances a crime against humanity, and therefore also triggering that obligation. But unlike persecution and unlike other forms of violations that the state is obliged to prosecute if they are crimes against humanity or war crimes, when it comes to torture and disappearances, even a single event gives rise to this obligation. And it means that there's no prosecutorial discretion, that there's no statute of limitations, that there's no pardons, no amnesties that can stand in the way of investigating, prosecuting, and punishing torture. But what I want to say particularly is that this obligation has some conditions of compliance with the international standard. It has to be an investigation that is prompt, that is independent, that is impartial, and that has the objective of finding out evidence about whether torture has occurred or not, and identifying perpetrators for possible prosecution. It follows also, although the Convention Against Torture doesn't say it, that the investigation has to be open and transparent. And therefore, part of the obligation is not only to investigate, but also to reveal the truth. The society, the community has a right to know what has been done in its name, and therefore the investigation cannot be a secret investigation, cannot be kind of a confidential results of the investigation. Obviously, this doesn't mean that there are no aspects of government work that will never be secret. There may be secrets, for example, with respect to sources and methods of intelligence gathering, but there cannot be any secrets with respect to human rights violations. It's as simple as that. I mean, you cannot invoke state secrets or any other kind of reason to conceal and to hide violations of fundamental human rights, like the right to physical and mental integrity. So this is this aspect of the transparency of the investigation is what sometimes in international law we call the right to truth. This has mostly come about when states investigate legacies of human rights abuses from the recent past, like in South America, in South Africa, etc. But it has become a well-established principle and standard of international law that victims and their relatives and the community at large have a right to know what happened in the course of the most serious violations of human rights, including the torture. So this brings me but I want to say that the right to truth is inextricably linked to the right to justice. It's not permissible for states to write a truth report and pretend that then you don't have to investigate, prosecute, and punish the serious crimes that the report includes. And this brings me to the Senate Select Committee on Intelligence report. But I should note that we sometimes forget that in 2008, the Senate Committee on Defense, on the Armed Services, I think it's called, chaired by Senator Levin at the time, wrote an excellent report on violations committed by the armed forces of the United States in Abu Ghraib, Bagram, etc., and abroad generally. It was a very forceful, very uncompromising report, but it specifically said that they couldn't deal with the CIA because they didn't have jurisdiction over it. And they announced that the Senate Committee on Intelligence was going to be doing its own report. But it's been, 6 years almost already, and only last December, the report by the Senate Committee on Intelligence has been revealed. And first, I want to say that it goes a long way in fulfilling the obligations of the United States under international law with regards to the right to truth. Not only because it is a report, but because it's a thorough report. It's a well-investigated report. It has taken a lot of effort to pore over documents and testimonies, and even to engage with the other side and to hear the other side's views. So in that sense, for all we know, because we only know the executive summary and a very heavily redacted summary at that, but from what we know, it does look like a report that fulfills the right to truth to a large extent. But like the High Commissioner of Human Rights for the United Nations and the Special Rapporteur on Human Rights while Countering Terrorism, and myself as Special Rapporteur on Torture, we have said, although we hail and we celebrate this report, we point out that this is not enough. That the obligation of the state with regards to international law is only partially satisfied by this report. The next step has to be the investigation, prosecution, and punishment. Now, obviously, I don't just because we urge the United States to do this, as does the Committee Against Torture, for example, that it's not going to make it happen. I don't want you to think that I am naive about that. But my experience in Latin America is that sometimes when things look like they will never happen, it just takes, continuing to push and building blocks like this report, I think, is a building block towards making it possible down the road for the United States to live up to its obligations under international law. But I do think that the report also has some limitations. And first, I would say that the decision to publish it 5 years later is to be lamented, because we've always known that there was a report, and we've never known the content until December. And the Select Committee on Intelligence have gone back and forth with the executive branch on what to release and when and how. And the White House unfortunately sent it back to the CIA to advise the White House as to what should be allowed to go public or not. And though it seemed during all of 2014 that at some point there'll be a decision, it's to be lamented that the decision was finally made by the Select Committee, or the majority at the time of the Select Committee, not by the White House, not by the executive branch. And then it triggered, well, of course, I also think we have to deplore the redactions that I mentioned before. It's still a readable document, but I think we need to know a little more about what's there under the black ink. And particularly, it seems to be based on a much longer and much more complete report that is not made public. So at some point or another, even under the obligation derived of the right to truth, the Senate and the executive branch should reveal the full report to the public to be analyzed by scholars and others over time. I am also a little disappointed at the debate that followed the release of the report, because I think it was, and perhaps this is attributable to the report itself or to the Select Committee itself, because it seems to concentrate too much on whether the CIA lied to Congress, lied to the Senate, or lied to the public, and also on whether torture works. And the two issues are related, because what the committee says is that the CIA misled the public in terms of saying that what the information intelligence obtained under torture was useful to prevent attacks on the United States, etc. Now, I would obviously prefer that the debate was about the morality of torture and and the legality of torture, where I think the arguments would be very different. Because I don't think there was ever any question that people who are tortured tell their torturer a lot of things, and that some of them are true. There's no question about that. I mean, anybody who argues that you always mislead the torturer is not right. I mean, the problem is that first, especially very hardened criminals and terrorists, they don't have any reason to reveal quickly under relatively mild forms of pressure information that they believe is crucial to the success of their mission, as it were, terrorist or organized crime mission. On the contrary, they have every reason to sustain as much as possible their pain and not only not reveal truthful information, but actually mislead interrogator into giving them, and by giving them misleading information. So for anybody who has studied torture over a long period and how it happens in real life, which I have, you know that that's the way torture takes place. And you end up torturing a lot of people, a lot of them innocent of anything, until you get a mass of information. And some of it will be true, but it's difficult for the interrogator to know which information is true and actionable, as they say. So in fact, it does disperse and send the interrogators into a wild goose chase, sometimes leading into very misled into things that have no productive value of any sort. But to say that some of it will, that none of it will ever be useful, of course, is not the argument, and it should never have been part of the argument. But I also think that the question of whether torture works, so to speak, cannot be seen in these very specific terms of whether it produces some actionable intelligence or not. It has to be seen in the broader sense of, one, whether it disperses efforts and misleads efforts that you need to concentrate and focus, but also on what kind of price you pay over time for engaging in a policy and pattern of torturing everybody. And that is not just a moral argument, it's also a very, and of course it's a legal argument, but it's more than anything a very practical, political, far-reaching argument. Because if you allow your forces, your security forces, your intelligence forces, your police to engage in a systematic and administrative policy of torturing every individual that comes their way, sooner or later you corrupt those institutions. Sooner or later the public doesn't have any confidence in them. And this is especially true, I think, of the situation of the United States, you create an easy recruiting tool for those people who want to continue attacking you. In addition, of course, you run the risk of not letting intelligence services or democratic governments that are generally willing to work with you, preventing them from collaborating and sharing intelligence, because their own publics are going to be telling them, we don't want anything to do with you in our name and with our tax money contributing to policies that are clearly illegal anymore. And my last point is on the question of the truthfulness, and the article by David Cole, a friend of all of us, and somebody who I admire a lot. I quite frankly don't see why there's any need to defend the veracity of the CIA, because first, the CIA fought publicly, fought the publication of the report every step of the way, and tried to, claiming to be truthful when you're trying to hide the truth seems to me not to be consistent. Even now, they refuse to call torture by its name. Even now, the CIA and its director insist on this euphemism of enhanced interrogation technique when the report describes what it is, and it is what Joe mentioned at the beginning, and refusing to call it by its name is also lack of truthfulness. Third, the CIA does admit some misrepresentations in specific cases, and misrepresentations made to the Congress and to the public. So at least as far as that goes, they haven't been all that truthful. And finally, they protect their agents and contractors, not only agents, by invoking the state secrets doctrine to protect sources and methods. And as I said before, there are legitimate reasons to protect sources and methods. But if you make them too extensive, you actually prevent disclosure of human rights violations. But the other way in which they want to protect agents and contractors is by supposedly reliance on the torture memos as legal authorization to torture, which seems to me to be a far-fetched argument, because you don't need to read the torture memos and you don't have a legitimate expectation that you're doing the right thing if you are banging somebody's head against the wall, if you're waterboarding somebody, if you are deliberately inflicting pain and suffering associated with torture for whatever purpose, even if you think that you are pursuing a lofty goal as protecting the security of the United States. The intent is the intent to inflict pain and suffering. And if it is, it's torture, and there's no two ways about it. Thank you very much.
Thank you, Juan. So I feel very honored and privileged to be sitting at this table with Juan, who's also one of my personal heroes. My name is Raha Walla. I'm a senior counsel for defense and intelligence at Human Rights First. As Joe mentioned, Human Rights First is an international human rights organization. We've been around for about 35 years, work on a variety of issues with respect to protecting human rights defenders around the world, protecting the rights of refugees and asylum seekers, working to fight against discrimination, combating human trafficking, and notably trying to reinforce human rights protections in the context of national security and counterterrorism policy. What I thought I'd do, Juan's presentation, it's always great to hear Juan because it's such a great framework for thinking about how international law applies in this case. And I think we sometimes forget the importance of international law when we're talking about political debates around national security. But it really is the foundational legal framework for thinking about when we're talking about torture or cruel, inhuman, and degrading treatment. What I wanted to do a little bit to maybe complement what Juan said was take us back in time, because I see a lot of young faces in this room, and we may forget a little bit about what our country actually did after 9/11. Before the 9/11 attacks, there was actually a pretty widespread agreement in this country, bipartisan agreement, that torture was wrong, unlawful, immoral, and that it ought never be used. There are actually CIA documents that date back to the 1980s that document the mistakes that were made in the past when the CIA engaged in interrogation policies that amounted to torture or abusive treatment, and how the CIA ought to not return to those policies. But of course, after 9/11, that's exactly where we ended up. So what happened after 9/11? Why did we end up with a policy of torture and abusive treatment? Why did the CIA get involved with black sites? Well, I mean, it's a pretty familiar story that I think has occurred throughout time whenever a country is faced with what it perceives to be an existential crisis or a state of emergency. Very shortly after 9/11, there were memos going around, and it's detailed in the Senate Intelligence Committee report, talking about the need for enhanced procedures to gather intelligence from terrorism suspects. And immediately, there were lawyers talking about the anti-torture statute and the Convention Against Torture, and what kind of defenses could be put into place to justify acts that would otherwise be considered torture. And when we're talking about waterboarding, and some of these other techniques, we have to remember these are techniques that maybe on paper sound dry, but in actuality are incredibly painful techniques. Waterboarding means strapping a human being to a board and shoving water down into their lungs to the point where it's not even simulated drowning, it's actual drowning. The Senate report documents individuals who were convulsing from pain, who were rendered unresponsive and unconscious from the degree of pain and suffering from waterboarding, who were held, in stress positions for upwards of 180 hours with sensory deprivation and deprived of sleep for days on end. Many have described, many who have been through torture have described sleep deprivation as the worst form of torture. And this is just the beginning of a whole host of torture techniques that were used after 9/11. These were techniques that were used abroad in what are called CIA black sites. So these were secret prisons in countries around the world, in Poland and Romania and Thailand, where we had consent from governments who were complicit to hold these sites and ship terrorism suspects to these sites to be held incommunicado without access to their lawyers, without access to any due process whatsoever, and tortured using these techniques. What I think is particularly sad to me, beyond the torture itself, is how little the government actually paid attention to the expert opinions that were out there. One of the things that we specialize in at Human Rights First is trying to partner with the national security community. So we work with a group of retired generals and admirals who believe very strongly that not only is torture immoral and illegal, but it harms the United States because of all the reasons that Juan said. It promotes terrorist recruitment, and it deprives the United States of its ability to work with allies on important counterterrorism matters. But we also work with a group of professional interrogators. These are some of the nation's top interrogators who have interrogated high-level terrorism suspects, and they all uniformly agree that torture is not the most reliable way to get intelligence. Yes, it sometimes can produce truthful statements from individuals, but on balance, think about a time in your life when you've been subjected to pain or suffering or shock. Your ability to recall information, your ability to transmit information is significantly diminished. This is basic kind of human psychology and cognitive theory, and interrogators intuitively know it, and it's supported by behavioral science as well. So when they actually were approached in the aftermath of 9/11, our professional interrogators, they wanted to have nothing to do with it because they knew not only that it was trouble, but that it would be a less effective way of gathering intelligence. So the CIA actually commissioned outside contractors to individuals who were not interrogators, who were psychologists, who were paid vast sums of money, upwards of $81 million, to develop an interrogation program from scratch that was based on unfounded psychological theories. And they went forth with an experiment on individuals held in our custody. And the result was the torture and the abuse that was detailed in the Senate report. So the Senate report, I would commend that you all read it. It's quite long, but it's actually at 500 pages, just the executive summary of a much longer, about 6,900-page volume that remains classified. At minimum, you should read the first 20 pages, which I think details in shocking detail the futility of this torture program. Not only was it incredibly brutal and widespread, but we had individuals who were subjected to torture right off the bat without even trying traditional interrogation techniques. We had individuals who had, Khalid Sheikh Mohammed, exposed to 183 waterboarding sessions, is telling interrogators that there is a cell of African American Muslims in Montana planning the next wave of terrorism attacks on the country. And all kinds of falsehoods like this that you would expect if you're being exposed to torture. Some of the key intelligence, faulty intelligence, that led us into the Iraq War, that justified the claim that there were weapons of mass destruction in Iraq that Saddam Hussein was planning to use against the United States, derived from the use of torture. This has been an incredibly costly policy for our country. And the CIA did lie. The CIA did misrepresent the facts. I don't think out of malicious intent, but I think with any government program, there's a sense of wanting to justify your actions and your behaviors. This was an incredibly sensitive program that I think government officials knew had to be justified in the strongest possible terms. So intelligence that was gathered through traditional interrogation techniques was written into memos as being gathered through enhanced interrogation techniques. Individuals who had provided intelligence before they were ever tortured, it was rewritten to say that they had provided after they were tortured. There is one after another example in the intelligence committee report that is really damning in explaining how in almost every single high-profile case where the CIA claimed that intelligence was necessary to thwart a terrorist attack or save American lives, it's just not true. And even if half of that intelligence committee report is true, I think it should lead us all to question whether this program was worth it, even if you don't agree with the legal and the moral aspects, which to me are quite clear. So one question that you all might be thinking about is where do we go from here? Well, as Juan said, there's an important push for accountability. To date, there's been no government official that has been prosecuted for the widespread and systematic use of torture by our country against over 100 individuals held in secret CIA sites around the world. That, to me, is a shocking statement, but it's true. No individual has been held accountable. There was a detainee, a guy named Gul Rahman in Afghanistan, who was literally frozen to death in a detention cell. This is not in dispute. The CIA doesn't even dispute this. No one has been held accountable. So I think there's an important push for accountability on the horizon. But in addition to that, what we want to do is we want to push bipartisan legislation in this Congress to make sure that the kinds of what I like to call loophole lawyering that enabled certain lawyers in the last Bush administration to basically write around the prohibitions against torture, to make sure that that can never happen again. In our view, all of this activity is clearly already illegal under both domestic and international law, but I think there are things that can be done. For example, establishing a single standard under the Army Field Manual for interrogation or other protections that can make sure that a future administration can never resort to torture again. You might remember, you may not, but when Obama came into office in 2009, one of his first official acts was that he signed an anti-torture executive order, which built on the federal laws that ban torture. But that executive order, as is the case with all executive orders, can be overturned by a future president. And in 2012, in fact, it was leaked to the press that candidate for president, Mitt Romney, his national security advisors were recommending that Mitt Romney, if elected president, rescind that anti-torture executive order and reestablish the so-called enhanced interrogation program. Let me say one thing about semantics, because it's very interesting to talk about, words and the power of words. In my view, one of the most destructive things in this entire debate has been the introduction of this concept of enhanced interrogation tactics. Not only is it a misnomer for the reasons that I said before, in that most interrogators, professional interrogators, believe that it's not enhanced at all and that it in fact detracts from accurate intelligence gathering, but it really takes the focus off of the fact that these are really, really abusive interrogation techniques. And I think even for those who support the use of these torture tactics, you ought to own that, right? Admit that you are inflicting pain and suffering on individuals in the first instance, and don't try to sanitize the concept by using some other word. And the media, in many ways, has been complicit in this for years on end. Before 9/11, we were referring to these same tactics, especially when used by other governments overseas, as torture tactics. But all of a sudden, when, after 9/11, the Bush administration started writing legal memos to try to rewrite the definition of torture, the media organizations started calling it, harsh interrogation, or stressful interrogation positions or enhanced interrogation positions. Well, no wonder the American public in majority supports the use of these interrogation techniques in some ways, despite the, I think, unhelpful debate that happened after the release of the Senate report around some of these issues. I think the one good thing that came out of it was this was called the Senate Torture Report for a reason. And even those who support the use of torture in some circumstances admitted, yeah, in reading these descriptions, these brutal descriptions of what was done to people, there's no question in my mind this amounts to torture. And so I think we've actually seen some media organizations now start to move in the direction of calling this what it is, which is torture. It's also worth noting, just to reinforce one of the legal framework concepts that Juan mentioned, which is that even if you don't, with some of these techniques, rise to the level of torture, and I think many, if most of them do, cruel, inhuman, and degrading treatment or punishment, which is the lesser form of abuse, is also prohibited universally. Under no circumstances can you inflict humiliating or degrading treatment or abusive treatment on an individual, even if it doesn't rise to the very severe level of torture. So in some ways, the debate about is it torture or is it not torture is kind of irrelevant, because all forms of abuse are unlawful and should not be permitted in any circumstances. So we will be working with other NGOs, other human rights organizations, with the Congress, with the administration, pushing forward for release of the full report, for accountability, for legislation to prevent these types of things from happening again in the future, partnering with Juan and his mandate as well. But I do think that my hope is at least that one of the key lessons that will come out of release of the Senate report is that we will all have a better understanding of what was actually done in our names as Americans, and that hopefully we will be that bulwark of support against any future attempt by an administration to enact a torture policy. And it saddens me to admit this, but this is not 9/11 was the first major terrorist attack that our country has faced. And hopefully it will be the last. But there will be other terrorist attacks, the Boston Marathon bombings, other Fort Hood attacks. And whenever one of these terrorist attacks happens, it renews this debate about should we be resorting to so-called enhanced interrogation. We need to put to rest that debate. We need to get beyond that. There are other ways to gather intelligence consistent with our values and our laws. And that's something that hopefully you all, as you're kind of entering your careers, will be able to really focus on and think about. Thank you very much.
Now, do you know what the vice president called? A former vice president. Who was your vice president for 8 years? You know what he called this report?
Bunch of crap.
What?
Bunch of crap.
What did, yeah, pile of crap, wasn't it? What he said?
Yeah.
Okay, wasn't not elegant language, but okay, we have 10 minutes for Q&A. I'm just going to get a couple of comments and questions, and then pitch it for a couple of comments and responses from you folks. Professor McCarthy.
Yes, thank you, brothers, for coming in with your time and your thoughts. Assuming that both of you think that there ought to be accountability and there ought to be some type of a prosecution and trial at a federal court, I assume, in this country, do you ardently favor, as I do, and believe that Bush and Cheney and Rice and the others will be found guilty? Do you favor that they get a long prison sentence, and which prison would you like to send them to?
Hi, I'm Illy, and I was just wondering if you guys could briefly explain how the ICC process works and how come different countries haven't, I don't know, why has it been in the international media?
The International Criminal Court, that's a big,
yeah, I think in like 2 years.
Yes, who are you?
Oh.
Just tell us your name.
Hi, my name is Grant Denny with the Westminster Program for the Foreign Policy Class with John Calabrese. I was wondering, could you give us a few examples of degrading and meeting torture or just interrogation techniques? Because honestly, this term is bogs to be demeaning. Exactly what would torturers do in these black sites against detainees for demeaning techniques?
Thank you. Yes, ma'am.
I'm Jackie, also with the SAM program. I was wondering, in terms of the follow-through after the investigations and stuff, should, or would it be based off of a similar model of like post-apartheid, the Truth and Reconciliation Commission, where public forums and people who have participated in the torture maybe apply for amnesty in exchange for their testimony and sort of pointing fingers all the way up to the top, that kind of thing?
If you can help me, I'm Dan Whitman, I'm a loiterer with a purpose. I'm trying to, I'm admitting this may be incorrect. Karen DeYoung, when she published a book about revealing secret actions in the U.S., I think she made the point that some of these functions were transferred from the CIA to the Pentagon because of a loophole in the law in 1947, which obliged the CIA to get tacit approval from the Senate Select Committee before doing actual covert actions, whereas the Pentagon does not have that obligation, and that this was one reason that some of the functions were shifted over. I think that may be a semantic question, but it may be institutionally important that some of these things, we keep talking about the CIA, DOD has taken over to some degree some of these functions. Correct me if I'm wrong.
Anybody else? Speak now, forever hold your peace. Yeah, real quick.
My name is Nelson Franco, and I'm just curious what you think the likelihood of actual legal action being taken on the basis of what's come out, or just overall, and what you think the most probable outcome of all of that might be. Whether that would be absolutely nothing, or criminal trials for the people who, held the immediate, responsibility for the actions, so the people who were the interrogators, or whether it would go up the higher echelons of, I guess, the ladder of responsibility.
Great. Here's my proposal. Let me handle the CIA DOD domestic legal question, and then why don't you take the rest, and I'll chip in where I can.
You should chip in. Yeah.
Sure. So just on the narrow question, it's true under the 1947 National Security Act that there needs to be a corporate finding, presidential finding, and reporting to the intelligence committees. Reporting to the intelligence committees in a way that is not required for DOD. That being said, in the narrow context of the interrogation program, there were parallel programs. So there was a DOD program that had similar but not all the same so-called enhanced interrogation techniques that was applied at Guantanamo, at Bagram, at Camp Bucca, other places, Abu Ghraib, and then there was also the CIA program that applied at the black sites. This is playing out a little bit more along the lines of what you suggested in the drone context, with respect to secrecy and congressional oversight on drones, and perhaps you were referring to that. But
yes, DOD, I think, more than it used to be. Right?
That's correct.
Yeah. Thank you.
With respect to whom to prosecute, the international standard on the right to justice requires states to prosecute in good faith and to the best of its abilities. It requires also to prosecute everybody up and down the chain of command, because it would be scapegoating to prosecute only those who perpetrated, and but at the same time, those who perpetrated should not escape the Nuremberg principle that obedience to orders is no defense when it comes to serious crimes like this. The problem is, the international law right to justice does not require convictions. It does require good faith effort. So, and it does require that it be done with the utmost respect for fair trial and other procedural guarantees. So yes, it would have to be in federal courts and with every available defense for those who might be suspects of the crime. I'm not in a position to say whom should they prosecute first or last. It's not up to an international special rapporteur to say whom you should prosecute. We want them to we want every state to prosecute everyone that might be responsible. In the case of international criminal justice, the standard is to prosecute those who bear the highest responsibility. But that's because international tribunals work under the principle of complementarity, and those bearing less responsibility have to be prosecuted by the domestic jurisdiction. In that same vein, then, likelihood of legal action, no, as I said, I mean, I am realistic. I know that it's not going to happen. I know that the United States, the Obama administration seems to think that this is that they'll be accused of, you know, using their power to get back at the political adversary rather than those bearing responsibilities for crime. Obviously, I don't agree with that, but it's part of the equation. And as I said, in all of the cases of prosecutions for human rights crimes everywhere in the world, it's always very difficult. This is the most difficult part for any state. So we understand. It doesn't mean that we agree or condone with impunity for these crimes, and it is our responsibility to insist on it, even if we sound naive, even if we sound like we don't really understand the situation. In respect to possible follow-ups, legal action, say through a policy of truth-telling with amnesty following, as in the so-called South African model, and I should say that that is an overly simplified description of the South African model. But I have to say, first, the only Truth Commission, and there's many, there's 40 or 50 that have happened in the last 30 years, the only Truth Commission that actually exchanged truth-telling for amnesty is the South African one. And many that came after, even though the South African model was highly praised, didn't follow that model because it didn't work, quite frankly. I mean, the TRC in South Africa worked very well in truth-telling, but it did not obtain a whole lot of information to prosecute with. It's also untrue that they didn't prosecute. There are a few cases, maybe a handful of cases, and only last week, I think, or 2 weeks ago, somebody who was sentenced to 20 years finally got out of prison. So surprises a lot of people that think that in South Africa no one was ever prosecuted. Yes, they were. Not as many as they should have, but some were. So I think the truth-telling aspect of this is important, but I think it should not be proposed as a substitute for the obligation to prosecute. It should be a way of generating attention and also to concentrating evidence. Now we have a good report, and prosecutors have places to start. Obviously, they have to develop evidence that can stand in court. It's not the same standard that is applied in the Senate in the Senate committee report. It's a more demanding standard when you actually go to a criminal court. But it's a good start. The prosecutors don't have to start from scratch. And my final point on the ICC, the International Criminal Court, first the so-called ad hoc courts that preceded and still operate for the former Yugoslavia and Rwanda were created by a decision of the Security Council. And they have a very limited jurisdiction, geographic jurisdiction, and time chronological jurisdiction as well, whereas the International Criminal Court is supposed to be a permanent court to have jurisdiction over every country that signs and ratifies it. The United States has not and will not sign and ratify the Statute of Rome, and so these cases of torture cannot go to the ICC, with the possible exceptions of those that happened in Afghanistan, because Afghanistan is a party to the Statute of Rome, and theoretically, at least, the ICC could bring a charge against an American agent for torture that happened in Afghanistan. But other than that, it cannot go. But quite frankly, the ICC was not created to substitute for a country with enormous judicial and other legal resources like the United States is. The ICC is there to act when a country is unwilling or unable to do the right thing. The United States is unwilling, but it's not unable. And so it's a matter of creating the will and insist on domestic prosecutions, not international prosecutions, because we're not going anywhere with that. Thank you.
One point on international prosecutions, which is there are some cases in Europe, in the European Court of Human Rights, which is a regional human rights court system, that are proceeding, and in fact there was a recent judgment against Poland for being complicit in the CIA torture program, and they now have to pay damages to
And the previous one against Macedonia.
yes, and ongoing additional ones as well. So we're kind of in this ironic posture now where the United States itself has been unwilling to pursue accountability domestically, but its overseas partners who participated in the program are facing accountability abroad, which is, in my view, quite a shameful development.